Transgender lunch money lawsuit. A bunch of states are now suing the Biden administration, the federal government, because they are saying they are trying to impose upon them gender identity and sexual orientation policies that they don't want in their local schools. As you can see here, it is the case of Tennessee versus Biden. It's really Tennessee versus the Department of Agriculture, which is the entity that doles out money for schools. And today we've got a lot to unpack. It's going to start off with learning where this lawsuit is originating from, and it comes from Tennessee. Tennessee Attorney General, his name is Herbert Slatery #2. We'll see what he has to share with us about his background, but also take a look. We've got the announcement of the lawsuit, which was just yesterday on July 26, and this is a follow-up to a June 22nd letter, a June 2022 letter that details why this is so necessary. So we'll get some background there before we actually jump into the criminal. This is a civil complaint that is about 137 pages. We'll hit the highlights of that, and then we'll leave it there. Now, as I mentioned, Herbert H Slatery, he's over from Tennessee. And on this channel, we've talked a lot about the idea of sort of federalism, and that we've got a growing battle between the U.S. federal government and various states. And there's states pushing back. They don't want to be the subject of the federal government when they are not functioning appropriately. And Herbert Slatery is here, and he says he was appointed by the Supreme Court there to serve an 8-year term. He's the chief legal officer of the state. He investigates and prosecutes civil actions for all sorts of claims against the U.S. government. He led a nationwide investigation into opioids and the Purdue Pharma, defended laws against violations that he said were taking place under the EPA, and so on. So that's who we're talking about. Now, back in June of this year, what happened was he got together with a whole slew of other individuals. We can see their names down here from a bunch of different states, and they all signed this letter. We've got Leslie from Arkansas, Marshall from Alabama, Taylor from Alaska, Florida, Carr, Brnovich from Arizona. Okay, all of these different attorneys general sign on to this. Shout out to Kansas, Indiana, North Dakota, Ohio, Oklahoma, South Carolina, Texas, Montana, and others. Right? Utah, all signed off on this thing, and they sent it over. CC'd the House, CC'd Chuck Schumer, CC'd Nancy Pelosi, Kevin McCarthy, and the others. And they're responding to a change in what the Biden administration has done. This letter came back from June 14th. They say, "Dear Mr. President, the USDA, which is the Department of Agriculture, the FDA, enforces these rules." And they just came back out on May 5th, right? And they imposed this new policy, a program of discrimination. The guidance states that it's to provide state agencies with operations and different instructions about, here it is, you see this right here, gender identity and sexual orientations. And it's only applying to programs that receive federal aid. So one of the themes, one of the theories that we've talked about when we have these federalism battles, the federal government versus the state government, is how does the government make the states comply? What is the enforcement modality, the enforcement mechanism? Oftentimes, it's the power of the purse, because there's a limited set of things the federal government can do. Everything else is reserved to the states. So what they'll do is they'll say that if you want this federal money, you've got to do what we say. Raise the drinking age, raise the speed limit, do what we say, we'll give you this money. And as state citizens, we still have to pay federal taxes, whether they give that back to us or not. Like, we're paying for it, and they demand that you comply with their rules if you want a little bit of that money back. It's a very disgusting system, but it's what we've got. Here, it says, by vastly expanding the concept of discrimination on the basis of sex, they're changing a definition via fiat through executive order in the Biden people team. They're including now gender identity and orientation. It imposes, they write, unlawful regulatory measures on state agencies. The inevitable result is going to be chaos. And so as the chief legal officers of our state, we have to explain to you why this guidance is unlawful and why we ask you to withdraw it. Number one, this was issued without our consultation. There's something called the Administrative Procedures Act that says that, you sort of have this reliance right. The schools relied on this money. Now the government is changing the rules. They're relying on the federal government not changing the rules. So their reliance right is being impacted. And this is saying you can't do that unless you go through the rules, and they have not been doing that. The guidance must be withdrawn because it was not issued in compliance with the APA. But that's done intentionally. They say the USDA has tried to circumvent the requirements because they know that they couldn't do it otherwise. Same pattern that we've seen with the CDC and other federal agencies. They know that if they go through the APA, because there's all these notice and comment periods and requirements in order to get stuff passed, they just don't do it. It's exactly what the CDC did when they made it illegal to throw people off of your property when they weren't paying their bills. We have long had a productive relationship with the federal government, says this attorney general. We'd like to continue this way, but the guidance flouts the rule of law and also relies on illegal analysis and bad guidance. Therefore, please address it. You just passed this new rule. We're asking you to revoke it. Please do that. Now, obviously, that is not going to happen. So yesterday, on July 26th, they made this announcement. This came over from Slatery's office, and it says, AG Slatery, after that letter went out and Biden people told him to basically get bent, they said, all right, fine, we're just going to sue you, okay? And here's what the lawsuit looks like. Attorney General out of Nashville, he's leading a 22-state coalition now. The lawsuit is seeking to stop the Biden administration from enforcing an expansive and unlawful interpretation of anti-discrimination laws under the threat of withdrawing key food assistance program funding. So it's the power of the purse. Follow our gender identity guidelines or lose your lunch money. In the complaint, multi-state coalition challenges new regulations imposed by the USDA, and we'll go through and take a look at the complaint along with some of the exhibits here. This was filed, as we can see, out of the United States District Court out of Tennessee, Knoxville Division. And take a look at all these different states you can see here. Kentucky, Missouri, Louisiana, everybody, right? 22, I think, are on this list. And then I think, is Utah on here? Yeah, Utah's on there too. So I think it's a total of 23 now. And this is a complaint for injunctive and declaratory relief. Let's go through it just a little bit. We'll hit the intro and then we'll wrap it up. Introduction says, President Biden directed federal agencies to rewrite federal law. And this is to prevent discrimination on the basis of gender identity and orientation. The USDA did this by ignoring procedural requirements, directives, and rules that make this difficult on us, the states. You just change your rules. You just take your pen out and mark your documents differently. We all have to live with it. And they write in their lawsuit, first, the department issued a memo updating the nutrition services complaint policy to include claims of discrimination. This is a new requirement. And it also is a flawed understanding of what actually constitutes discrimination. Attached to the memorandum was a questions and answers document saying that they're updating their procedures and that they provided additional guidance a short time later. But the department compounded errors, and collectively what they have done through all of these different changes, what they're explaining is happening here. It's like, you pass a law, and then what you do is you create a brochure that explains the law. And so what they did is they didn't change the actual law because that's a lot of work. What they did is they just changed the brochure. And the brochure sort of interprets the law differently. We can do this a little bit differently. And now they're passing out the brochures. And they're saying to the schools, this is what we do now. If you don't do what we do now, according to this brochure, well, then you're in violation of the law. And therefore, we're going to take our lunch money away from you. And what they said is they changed all these brochures. They changed all these manuals. They changed all these guidance things. And they say, look, collectively, the memoranda and the final rules, they inappropriately expand the law far beyond what the statutory text, the requirements, and the precedent and the Constitution allows. You are not allowed to do that, is what they're saying. You can't just sort of give us this updated pamphlet and expect us to change everything. The department claims the interpretations are required by the decision, but that was a narrow decision and you're misinterpreting this. The department memoranda concern highly controversial and local issues of enormous importance to the states in addition to this, right? Not only did you not go through the APA, which would tell you how to legitimately update these rules and your brochures, but you're usurping these issues away from the states. their subdivisions, and their citizens. The department has no power to settle these issues, let alone by executive fiat without providing any opportunity for public comment. You don't just get to change the rules. Plaintiffs here, Arizona, Tennessee, Indiana, many other states, shout out to all of you, are suing to prevent the department from usurping authority that properly belongs to Congress, the states, and the people, and to eliminate the nationwide confusion and the upheaval that the department guidance has inflicted on states and entities. Now, to be clear, right, these AGs, they're saying, look, we are not denying benefits based on somebody's orientation or identity. We're not doing that. But we are saying that this is unlawful and unnecessary. It imposes new obligations upon us, along with new liabilities. And this is going too far. And pay attention to this last line here. This can be stretched. They're saying their concern is this gets stretched all the way out to ending sex-separated living facilities, right? So gendered, biological sexed living facilities. Get rid of them. Athletics. Those are discriminatory based on gender. So do athletics now go away, or else the feds take away your lunch money? And mandating the use of biologically inaccurate preferred pronouns, right? That's all discriminatory. What if somebody mispronounced somebody? And part of the new change says that you have to investigate these things if you want that lunch money. Here, significant amount of money. We're talking about $28 billion in funding for SNAP benefits. $28 billion in lunch money. Those benefits were distributed to 15 million people all across the various states. And that's why they're filing a lawsuit, saying that this is all taking place outside of the proper right. Look at this. This is 137 pages, so I'm not going to bore you with all of this legalese. But here, let's just take a look and see if we can see any big chunks. Yeah, it's mostly, these lawsuits are pretty bland and boring. We have all sorts of exhibits down here. Here is a federal share of the certification costs of the different billions of dollars, household dollars that are in there. All right, so they're making their case that the government just can't take this right away from them. And we'll see where this ultimately goes. Now, the Biden people are going to be responding to the lawsuit, of course. They're going to probably make many of the same arguments that we saw in many of the CDC cases, where they say, no, we have sort of plenary power. We can go do these things. And oftentimes these lawsuits have to go up to a district court, and a federal judge has to say, you stepped over the bounds. You stepped outside of your hula hoops, and it's not appropriate for you to just sort of make substantive changes to the law when you don't have the authority to do so. And so we will continue to cover that case. It's going to show up on the docket. I expect it to be something that is highly contentious because people care about their kids and their schools and their lunches. And so that, my friends, is it for the stories on the day.